Right, let's take you back to this story. The public protector is being victimized by the most powerful forces in the country. The Western Cape High Court has heard. Mpofu also contends an SMS sent to Parliament's lawyer in these proceedings about a constitutional court judgment that was yet to be delivered was deliberately intended to disadvantage her. Mpofu is in the same court for the second time in 2 years in an attempt to put a stop to Parliament's impeachment inquiry and to prevent her suspension. Let's go to Lindsay Dentlinger, who has been following proceedings for us. She joins us now live. Lindsay, that infamous SMS that was sent apparently by an employee at the JSE to the National Assembly Speaker or to somebody, a leak. Just remind us again what this SMS exactly was about and how it's been discussed in court today.
So, Maseko, since we last spoke earlier this morning, that SMS has dominated quite substantially in arguments in the last 2 hours or so. And just to refresh your memory, when we were in this court about 3 weeks ago, this matter didn't get off the ground as it should have at the time because of an SMS sent to Parliament's lawyer, Advocate Breitenbach, by a Mr. Abramji, who alleged at the time that a matter that the Constitutional Court was still to hand down judgment in which the public protector was seeking to have an earlier judgment rescinded, that it would not go in her favour. Subsequently, that judgment has been handed down. It did not go in her favour as predicted at the time, but her legal representative, Mpofu, telling the court today that really this matter should not proceed until this investigation that we now know the Chief Justice has ordered a probe, until all of that is ironed out, because it really casts a pall over the judiciary. And he says that that SMS was deliberately intended to disadvantage the public protector, else that SMS could have been sent to him, for example, or any of the other lawyers who are participating and representing various parties in this proceedings. So a really contentious matter right now before the court about this SMS, and whether these proceedings where I currently am should continue in light of those developments. But let's take a listen to part of that argument that Mpofu put before the court a little earlier.
There is a possibility out there that somebody in the Constitutional Court leaked a judgment to influence this court, with respect. Not out of fun or as a joyride, but to influence the 3 justices sitting here. If that was not the case, that SMS would not have been sent to Advocate Breitenbach. It should have been sent to me or Mr. Masuku or whoever. It is a deliberate act of criminality and corruption.
Of course, she's also challenging the possibility of being suspended by the president. Has this been discussed in court as well?
Yes, so that just until we had a short break now for the lunch adjournment, that has really been the discussions that we're on right now about whether the president is the correct person to even consider suspending the public protector. Earlier we heard the legal representative said that this would be extremely unfair and a double whammy, because a suspension would impugn on her reputation and the work of her office. But the latter arguments that we have just heard in regard to this suspension is the public protector contending that the president is highly conflicted. There are at least 3 matters involving him that she's investigated that's also before the courts, and these in itself, her lawyer has contended, are impeachable offences for the president, and so for them it doesn't stand to reason that he is the person in the right position to be able to even consider suspending the public protector while Parliament initiates this inquiry against her, and so it's telling the court that it, as recently as Sunday, has still been communicating with the president through various letters about the fact that they do not believe that he should be the one to even consider suspending her. But here's Dali Mpofu again on that score.
People live not by bread alone. Indeed, in the case of career functionaries, reputation and bread are inseparable. I don't think that needs any further explanation. But to round off the point before we take a short break, the point I was simply making really is that assuming that it is not contestable that an impeachment provision such as Section 89, 177 or 194 is ipso facto punitive, which is what, well, it can be debatable because that's what the Constitutional Court said. Assuming that is not debatable, and assuming the second proposition I was making, which is that this is a double whammy, if you like, or a double punitive provision.
All right, Lindsay, let's leave you to it. I believe it's a lunch break and you're back in court at 2 o'clock. That was Lindsay Dentlinger reporting for us from the High Court in the Western Cape.